Good morning or afternoon, depending on where you're joining from. Welcome to our webinar, Navigating SMS Compliance, brought to you by MessageMedia and Manat, Phelps & Phillips. My name is Mark Rothert. I'm president of MessageMedia, and I'll be your host today. I'm joined by Mark Roth, who's a partner at Manat, Phelps & Phillips, and Mark is one of the leading experts in TCPA. Thank you for joining us. I think most of you are MessageMedia customers, and we appreciate your business. We also appreciate you joining today's webinar. Compliance is a topic that we take quite seriously, and we know that you as our customers sometimes have questions and confusion around SMS compliance, and that's the objective of today's webinar, is to answer some of those questions and clear up some of that confusion. And so to do that, we've invited Mark to join us and to present on the topic of SMS compliance. Before I turn it over to Mark, I wanted to cover a few housekeeping items. First of all, the webinar is scheduled for 45 minutes. We've got a lot of ground to cover, and we'll try to get it all covered in 45 minutes and then save a few minutes for question and answer at the end. If you do have questions during the webinar, please submit them via the chat interface in the GoToWebinar application. And finally, the webinar is being recorded. We will share a link to the recording with all the attendees and registrants after the webinar. With that, over to you, Mark.
Thank you very much, Mark. And hopefully everyone is sufficiently confused now between Mark Roth and Mark Rothert. Obviously not by design, but just coincidence. And I'm happy to have been asked by MessageMedia to participate in this program. The program really comes out of Mark's idea that he was receiving a number of questions from clients, and there's a number of confusion and misunderstandings as to how the TCPA is enforced and what the nuances are. So he had the brilliant idea of having a webinar for his customers to help clarify and to help inform clients better on what the nuances are so that they can navigate their business more efficiently with greater clarity. So I appreciate the opportunity to participate in this program. I want to start off by saying that we're going to be talking about the TCPA, which I'm sure many of you are familiar with, if not everyone. And there are various aspects of the TCPA that we are not going to be covering today. The TCPA prohibits, for example, unsolicited facsimiles. There are also caller ID requirements and call abandonment requirements and other type of other issues that we're really not going to discuss today. We're just going to be discussing SMS compliance, given that's the nature of what this of what the business is here. So today's agenda, it's a pretty aggressive agenda for 45 minutes, and hopefully we will get through it all. And hopefully leave some time at the end for some questions, which we're happy to entertain. The first topic, we're going to give a TCPA overview, what the TCPA is about, what the purpose is, etc. Very importantly, consent requirements under the TCPA for informational messages, telemarketing messages. Talk about what dual purpose messages are. Also, an interesting topic that came up recently, about 2 years ago, in July 2015 ruling by the FCC, revocation of consents. How can consumers revoke previously provided consent, which has been a hotbed of issues and confusion, and an issue that the courts are dealing with right now. Similarly, we're going to be talking about another topic raised by the 2015 ruling having to do with reassigned numbers. This is where a consumer may consent to receive a text message or a phone call, and then abandon, for whatever reason, that phone number, and it gets assigned to someone else. And what type of liability can a caller have there? We're also going to be rounding it up then with how to mitigate risk, how to do and engage some best practices so that your risk profile is reduced. And then, as I mentioned a moment ago, as did Mark said as well, we're going to have some time hopefully for Q&A. Whether they could be submitted, I'm not sure, by phone, that's up to Mark, or through the webinar application itself. So let's get into the meat of it now. The TCPA, as you may or may not know, was enacted in 1991. By the way, just as I know, way before cell phones became a primary or dominant use communication device by consumers. It was enacted in 1991 to primarily address consumer privacy, because cell phones were starting to be used, with a little bit greater frequency, and people getting called on their mobile phones was a little bit of an annoyance. So Congress felt that they needed to step in that space. Pre-recorded telemarketing robocalls to residences, which were considered an invasion of privacy, and as I just mentioned a moment ago as well, calls to mobile phones. The importance here, in addition to a privacy issue, is that the cost, at least back then, of receiving a call shifted from the caller to the recipient of the call. When folks had to pay for each inbound call, or even an all-you-can-eat plan where the calls are taken out of your plan minutes, the cost shifted to the recipient, which is a real problem because if you did not have consent to, if you did not give consent to receive the calls, you're being charged for something that you didn't know you were going to get. It also authorized an establishment of federal do not call list. The do not call list regulations are shared with the FTC's telemarketing sales rule, and the two of them are harmonized. We'll be talking a little bit about that, but not in great detail here. The TCPA also established rules regarding the types of consent required to make certain calls. And we should also point out here, too, which may be obvious to everyone, that text messages are considered calls to wireless devices under the TCPA. The TCPA also granted the FCC regulatory enforcement authority, but importantly also provides consumer private right of action. That is probably the most significant risk under the TCPA, the private right of action, because the FCC has limited resources, has to use prosecutorial discretion when deciding what type of cases to bring. So they can't bring every case. On the other hand, the private right of action allows anyone sitting home in their pajamas to get a phone call or a text message and then sue a company if they did not give appropriate consent. And that's, again, the biggest threat to industry there. And consumers are entitled to get $500 per call or text or actual damages, whichever is greater, and up to $1,500 per call or text if the wrongful text is willful or knowing. And so there's a real big financial incentive for consumers to bring claims against companies that are not complying with the law or not doing it right. So now we turn to really the meat of the presentation, which is TCPA consent requirements. Basically, you have to get consumer consent if you're using an auto dialer to call a mobile phone or to send text messages. A couple of interesting words in there. Auto dialer, what is that? An auto dialer is any type of device that has the capacity to send out text messages or make phone calls on its own, hence the name auto dialer. There have been a number of courts that have distinguished between an auto dialer for purposes of making phone calls and then also a texting platform. A texting platform could have the capacity, that's a key word there, to automatically send out text messages. But a number of courts, I would say at this point, a predominant number of courts have found that these machines they're dummy machines, these platforms. They can't do anything by themselves. You have to load numbers into the system, into the platform, and then also load content, the text messages itself, and then hit send. And without that type of activity, it cannot happen automatically. So in a number of fronts, a number of courts have held that a text message platform is not an auto dialer. But some courts have held that it's an auto dialer. So we need to be cognizant of that issue. Now, there are different levels of consent that are required based and they're determined by the intended type of call or text message. For a purely informational or transactional message, a lower level of consent is required, whereas for a commercial or telemarketing may be considered more invasive and you need to have a different level of consent. We're going to be talking about this in just a second. The informational or transactional messages requires prior express consent, and commercial telemarketing requires prior express written consent. The distinction there is the word written, which is actually a misnomer because it doesn't necessarily have to be in writing. It could be done through IVR or online. And there's also certain disclosure requirements regarding the commercial telemarketing requirement. There's some exemptions under the TCPA. For example, emergency notices, weather alerts. For those of you who might be in the Northeast like I am today, where schools were closed, as were many offices. The best way to reach people is by mobile phone or by text message. So if you were like us and received a text message from the school last night, closing schools, that's considered an emergency, and that is permitted without even getting consent from a consumer. Carrier services messages, AT&T, Verizon, Sprint, some of the other carriers, they have the right to notify you, for example, if you're roaming, or if you may be incurring greater charges than your plan, or if you'd be approaching your minutes, they can notify you as long as it's called a free message. And last, we have healthcare messages under HIPAA. This exemption came out of the FCC's 2012 ruling, where they determined that HIPAA, the Health Information Portability and Accountability Act, provided similar, if not greater, privacy protections for consumers. And so that if any type of message satisfies the HIPAA requirements, then they would be satisfying TCPA. So the Federal Communications Commission provided an exemption for healthcare messages that are subject to under HIPAA. So now we're going to start talking about the different types of calls. Interestingly about the word, we're going to talk about informational calls under the TCPA. We have a whole bunch of examples here. And I'll just actually put it here because I know folks are probably waiting to say, what are informational calls? We have debt collection calls, political purposes, airline notification calls, for example, when a flight's delayed. It's important information, bank credit card balance, and fraud alerts. The goal here is that it's not selling anything. It's not attempting to sell. It's really just providing information in regard to a prior transaction. And so that requires a lower level of consent because it's not as invasive. And they might be, to use the terms of the FCC, expected by consumers and desired by consumers. Research or survey calls are also exempt. Wireless unit usage notifications. Here, I'll just give a few more examples here, which I won't read, but you can see on the screen. The important thing to note about this is that these are, again, all messages that might be desired or expected by consumers. They're not selling anything. The term informational is not defined under the TCPA or the TCPA rules implemented by the FCC. Very often you hear the word informational or transactional. Neither of these terms are defined. What is defined is, and we're going to get to in just a moment, is the term marketing. And marketing means either an advertisement or telemarketing. So it's almost the negative here. If it's not marketing or telemarketing or an advertisement, then it falls outside and thus becomes informational. So there's really kind of a moving target there on what's really informational because there's no hard and fast definition. And so the FCC has given examples of what this might be, but there's no hard definition to point to. Many companies, though, utilize texting platforms, such as MessageMedia, to deliver this type of content to their customers and others with whom they have a relationship, because, again, they want to reach them in a very directed manner and somewhere where consumers will receive that message. Not everyone receives emails. So by sending a text message, it's pretty sure to be delivered, and it'll be important information. Now, the consent requirements for informational calls, as I said, it's purely for informational or transactional messages, and it requires the recipient's prior express consent. The term prior express consent, similar to the word informational, is not defined by the TCPA or by the FCC. However, the FCC said that persons who knowingly release their number have in effect given their invitation or permission to be called at the number which they have given, absent instructions to the contrary. The last part of that sentence meaning an opt-out request, or don't call me. So what does that mean? If someone provides their mobile number to you, they have effectively given you consent to contact them using that phone number, either by calling them or by texting them, but for only informational or transactional messages, not for marketing. And don't get hung up on the word express there. Very often you'll see express consent meaning an affirmative opt-in required. That's not the case here. Here it's merely the provision of the phone number by the consumer to the intended caller. Consent can be provided either verbally or written. It can be done on a piece of paper. It can be done online. It can be done by phone as well. So there's many different ways that this the consent can be granted. This consent can also be revoked, however, at any time, as the FCC has said, in any reasonable manner. So if someone replies back to a text message, stop or end, or calls you or sends you a letter that says, please stop texting me using my phone number that I previously gave, that could be a reasonable manner by which to opt out. There's a big issue right now with how revocation is being treated. The right to revoke consent actually arose out of a July 2015 ruling and order from the FCC, where it made clear that you can revoke consent and it can be done by any reasonable manner. But as with all nebulous and ambiguous terms such as reasonable manner, what does that mean? Some courts have now opined on it. In some areas of the country, others have not. And a number of industry groups have petitioned the FCC to clarify what's meant by reasonable manner. What they'd like to see is a manner that's been provided by the caller. So you can reply stop or end. But for example, if you have a retail store, is it reasonable for someone to walk into my retail store, hand a sales associate a piece of paper that says, don't text me anymore? Is that reasonable? Operationally, it definitely presents challenges. So that's right now being litigated, as a matter of fact, because these industry petitioned the court to review the FCC rules, and the courts are also struggling with that as well. Very, very important here is that recent case law now considers the context in which a telephone number is provided. Shifting back to the consent and back away from revocation, when someone gives their phone number, whereas the FCC content, the disclosures you see above, says that if they only give their phone number, that's enough. The courts have said that may not be enough. They actually now look to the context in which the number was provided. Does the consumer have a reasonable expectation to receive text messages or phone calls on that number that they provide? Or is it not reasonable? They may give it for one purpose, but then receive a text message for another purpose. Again, not marketing. So the courts now have said that, and they're pretty consistent, that you really need to look at the context of whether or not the consumer has that reasonable expectation that their number will be used to be reached. And not just in theory, but in practice, one court has even gone so far as to say that the consent can only be used in connection with the transaction for which or under which the number was provided. So if they bought something from you and you need to notify them that something will be delivered late, you can only contact them in regard to that purchase. You can't then contact them with other information. So that's also a developing area of law that we need to follow. But it's important to understand when you're relying on prior express consent for informational calls and text messages. So now let's talk about telemarketing calls. This definition, this issue arose again, as I mentioned a second ago, in the FCC 2012 report and order that distinguished between non-marketing and marketing. And here they actually define telemarketing, which is either an advertisement or a call that constitutes telemarketing. Both of these terms are broadly defined in the TCPA rules. For example, advertisement talks about any material advertising the commercial availability or quality of any products, goods, or services. That is pretty broad. It doesn't mean you're trying to sell anything. It just says advertising the availability or quality. You could be talking about something or just saying this is available, but not giving any prices or even inviting a consumer to purchase from you. That would satisfy the definition of advertisement. Similarly, we have a definition of telemarketing. It's a little bit narrower. The initiation of a telephone call or message for the purpose, now we have a purpose, of encouraging the purchase or rental or investment in property, goods, or services. So here you have the words purpose of encouraging, whereas advertisement doesn't have those more limiting words. Nevertheless, the requirement to get consent for a telemarketing call, or a marketing call rather, includes both of these definitions. So it's not satisfying one or the other. It is satisfying either one or the other. It doesn't have to satisfy or both. Also, as I said a moment ago, a sale is not required on the call itself. It really just needs to be talking about about the availability or quality of a product or service. This is where a big piece of a large area of confusion. Many companies think that because they have a relationship with a customer that they can text them. That is not true. You have to get the number from the consumer in some form. That is the element of consent there. You cannot what's called skip trace. You cannot go through third parties to find numbers and then text them, or third-party databases. You need some form of consent, even if you have a relationship with that consumer. And so what does telemarketing calls require? Prior express written consent, as I mentioned just a moment ago. In order to get this consent, it has the word written in there, but it also can be done electronically. The twist here is that there needs to be certain disclosures in the consent. And these are what I call the magic words. They're bolded here. Two elements. One, that by executing the agreement, consumer authorizes the seller to deliver telemarketing calls using an automatic telephone dialing system. Those words are in the regs. Automatic telephone dialing system, or an artificial pre-recorded about today, such as pre-recorded marketing messages to people's to their landlines, regardless of whether or not an auto dialer is used. But we're not going to be discussing that today, but it is an element of TCPA. So you have to use the words automatic telephone dialing system, and also that the person is not required to sign the agreement or enter into the agreement as a condition of purchasing any products, goods, or services. That's the second prong of the magic words. Now, what does that mean for texting? To put the words automatic telephone dialing system into a consent for texting, frankly, makes no sense. And the FCC didn't really think about that when they came up with these rules. If you're getting someone to opt in for marketing for text, through text message, to put the words automatic telephone dialing system, one, could confuse, and two, scare people. Maybe now they're going to think they're going to get telephone calls, and they don't want telephone calls. They just want to get text messages. So what industry has, and a number of companies have kind of, to address this issue, they've said, now, I agree to receive automated text messages from XYZ company. So the word automated being in lieu of the words automatic telephone dialing system. And to date, we've not seen any challenges to those, to that attempt to address what the statute and the rules require, but not using the exact words in the rules. And then secondly, the second disclosure is also somewhat of a, not a misnomer, but it could be confusing, because if someone's sending up for text alerts for whatever reason, whether it's a refill reminder or sports scores or something like that, and there's nothing for sale, they're not selling any purchase or product or service, to put this disclosure in there may think, well, wait a second, am I purchasing something here? What am I signing up for? So these words could be somewhat confusing and frightening to a consumer, but the way the FCC regulations came out, these are required disclosures for prior express written consent. As I mentioned a few moments ago, consent can be obtained either in print, online, or through an interactive voice response system, as long as the IVR is recorded. Importantly, the agreement must include the consumer's wireless number. It can't be collected through ANI, that's automated number identification. The consumer has to provide their phone number. Big question comes out, well, if they provided their phone number once before, now you're referencing back to the number that it is on file, whether or not that would be sufficient. And we've not seen any courts address that issue. But the consumer at some point must have given you the phone number. Here we hear some sample agreement language that can be used online. It could also be transferred to IVR as well. By clicking or signing below, replying to this email, I consent to receive phone calls from company regarding company's products and services, the numbers above, including my wireless number if provided. I understand they may be generated using, here's the words, automated technology, and that my consent is not required to make a purchase. That kind of encapsulates the disclosures in kind of a user-friendly way that may not be confusing, it may not scare people off, and it should achieve the intended goal. And so obviously it could be tweaked according to the intended usage, but that's kind of a standard compliant disclosure there. Importantly also, you have to get the consumer's signature, and on paper that is relatively simple. Let me go back there, sorry, just jumped ahead. On paper, it's relatively simple. If you're going to do it by online or IVR, you have to satisfy the eSign Act. That's the Electronic Signatures in Commerce Act that was enacted probably well over a decade ago, to give equal dignity to electronic contracts and agreements as would be in paper. And in order to do that, the signature would be done by clicking or pressing a button. But importantly, for the phone, for example, it must be recorded. Why? It's a defense for you, because then if you are ever challenged by a consumer as to whether or not you ever gave consent, you can point to the recording and say, we do have a recording. We also advise clients to hold on to these consents for at least 4 years, which is the statute of limitations under the TCPA. And so as a way, it's advisable to figure out a way where all this information can be stored electronically rather than holding on to paper for these purposes. Then a question comes up is, what happens if a text message contains both marketing content? How is that treated? And the answer is that calls or texts that contain both informational and telemarketing content are considered by the FCB to be telemarketing for purposes of the TCPA. That makes sense. Otherwise, you would have companies trying to hide behind an informational message, but by also sliding in a marketing message and saying, oh, I'm not covered. And that's not the case. It will be considered a telemarketing telemarketing call. As also, it doesn't matter that the sale is not completed during the call, because remember, if we go back to the definition of advertisement, all it's speaking to is the availability or quality of any product or service. It doesn't need to be selling anything. So some questionable messages that I get questions from all clients all the time. We value your business. Is that marketing? I would take the position it's not selling anything. It's a statement. We value your business. It's a feel-good message. So I'm not so concerned with something like that. But differing minds can differ, and you may be hearing from other legal counsel that may be stepping over the line or getting too close. Similarly, including a website URL in a text message. Depends on the context, is what I tell clients. If you're providing it as maybe, for example, customer service, or if they're buying something, or do you want to see our thank you for purchasing this thing, here are the terms of the transaction. That's not selling, and it's providing information that someone can click on, a URL, to see the terms. So that would be purely, in my mind, informational. If, however, you say, visit our website for great deals, well, that to me now steps over the line and goes to marketing. So it really depends on the context in which the URL is provided. Some examples addressed in the FTC report and order also that are hybrid, that are dual purpose. Calls from a mortgage broker notifying them of lower interest rates. One would think at first glance that that's informational, and that, oh, the rates have gone lower, maybe I'll refinance. But because the mortgage broker stands to make money, and you have to probably pay fees, that could at least in the FCC's eyes, be considered dual purpose. Calls from phone companies regarding new calling plans. That's also borderline, but if the phone company is informing you of the availability of new rates or new services that they offer, or new calling plans, that can very well be considered marketing. And last, and similar to the others as well, calls from credit card companies offering overdraft protection. There we go. Again, this is a positive for consumers. It's something that they probably would want to know about. But if it's protection, odds are that there's a fee involved there, and it speaks to the availability of a service. So that, again, I think presents a risk there. And even if the FCC does not enforce these regs as strictly as their wording is here, where their views are laid out, no doubt there will be a plaintiff's counsel somewhere that sees a text message campaign or solicits consumers who are receiving messages like this to try to solicit them to step up and file a class action based on these dual-purpose messages. They would probably look to the deep pockets of the company to see where the risk is there. So in those types of areas, your advice is speak with legal counsel, speak with your vendors to see whether or not the message would be considered a dual message. We talked a moment ago about revocation of consent. This issue came up in the July 2015 ruling from the FCC, among other topics as well, because under the TCPA and the TCPA rules implemented by the FCC, there is no express right for consumers to revoke consent. And a number of lawsuits were brought based on consumers contacting companies saying, stop contacting me using this phone number going forward. And some companies took the position like, well, you don't have the right to revoke consent. That's a pretty extreme position, but again, many companies took that position. And from my perspective, it was kind of even though it's not in the rules or the TCPA, it at least is a reasonable and should have the right, consumers should have the right to revoke their consent. And so a number of petitions were filed with the FCC by industry, by companies that were involved in litigation, seeking clarification as to whether or not they have the right consumers have the right to revoke a consent. Also chiming in on the issue were consumer advocacy groups, consumers union, and many others, and other privacy groups as well, saying by all means, consumers should have the right to opt out or revoke their consent. And so the FCC took all this information together, and the question they were faced with here was, and the ruling was that the consumers may revoke previously given consent at any time by any reasonable means. Obviously, they didn't define the term any reasonable means, but they did give some clarity which said that the called party, the consumer, must clearly express a desire not to receive further calls. And so that a number of defendants now have used those words, and there have been a number of cases handed down in the revocation issue that decided whether or not a consumer clearly expressed a desire not to receive further phone calls. And so at least, okay, on the FCC regs here, before I get into the case law, what does reasonable mean? It could be oral or in writing, the FCC has said. It could be consumer initiated. A call, consumer can call in and say, don't call, I want to take back my consent, or it can be in-store bill payment. If you go to a store and pay your bills and say, I don't want you to contact me anymore, that could be done there as well. The FCC had indicated that it will look at the totality of the circumstances surrounding a revocation request. Whether the consumer had a reasonable expectation that he or she could effectively communicate a revocation in that circumstance. But the FCC also said that whether a caller could have implemented mechanisms to effectuate a revocation request without incurring undue burden. So let's play this scenario out. And as a matter of fact, one of the dissenting commissioners at the FCC who dissented from the majority in allowing revocation said, does that mean that someone can walk into a fast food restaurant and when ordering food, tell the server, don't text me anymore, don't call me anymore? Would that be reasonable? And you have something to consider too as well, does it place an undue burden on the fast food chain to have to implement procedures to collect and to educate all of its sales folks as to how to handle these revocations, then report it to management or to report it to a central database? So all of this needs to be considered. Recently now, courts have had the opportunity to opine in this area where some consumers have said, I've revoked consent, and companies continue to call them, and the courts were faced with the question of whether or not someone sufficiently, within a reasonable mean, revoked their consent. And without getting into the minutiae of all these decisions, one in particular I wanted to raise where a consumer terminated their relationship with the company. They canceled, for example, a subscription. It had to do with a healthcare subscription, a healthcare club, not a subscription to membership. But they never specifically revoked their consent. So if you go back up on the slide where it says called party must clearly express a desire not to receive calls, a court found that the consumer never did that. They never made that request clearly express. They just canceled their membership and it went on their way. And so this is an evolving area, but there is some now guidance given by the courts, which has been very helpful. Also, as I mentioned a few moments ago, there are petitions, not even petitions, a number of petitions were filed in the D.C. Circuit for the District of Columbia, questioning and challenging the FCC's regulations having to do with revocation, among other topics as well. And one of the issues, and it's actually a court case where the circuit has to decide whether or not the FCC either stepped over its bounds, or if it's not clear enough in providing its rules and regulations, if revocation for reasonable means is legitimate or not. So that remains to be seen where that's going to go. Another issue that was raised and that came out of the July 2015 ruling had to do with reassigned wireless numbers. The issue presented here was whether a caller has liability for calling a number for which he had appropriate consent, but the number was reassigned to a new subscriber. Now remember also, texts are calls. So whenever there's used the word calls anywhere, it also means text. In the FCC's July 2015 ruling, they determined and they stated that a call party, because it's called party in the TCPA language, is the current subscriber who owns that number, or a non-subscriber, customer, user of the phone, such as a member of the family. So what does that mean? It means that it's the person who is currently subscribed to that number that's called. The FCC rejected proposals to interpret as an intended recipient. The issue here was that companies that had consent would attempt to reach out to consumers intending to reach John Doe because they had consent from John Doe for that number. But it was then reassigned to someone else, unbeknownst to the caller, to someone else, to Mary Smith, and now Mary Smith is reached. Company felt that I'm trying to reach John Doe. I didn't know anything about Mary Smith, so I should not have liability. The FCC rejected that, and it's now the called party. Interesting now, what they said was that, though, companies will have liability for calling reassigned wireless numbers, but they tried to come up with some type of safe harbor that you get a free pass for the first call made after reassignment. This is probably the craziest piece of the rules, because now if you call someone, they don't have any obligation to tell you that the number's been reassigned, that they're the new subscriber to the number, but you have to, through divine knowledge, know that the number was reassigned. It's entirely a unreasonable and fictitious belief that a company can understand this. So you get one bite at the apple, but then every future call would then you'll incur liability. And it makes no sense, frankly. And this is also one of the issues right before the districts for the circuit for D.C. In Washington D.C. is that whether or not this reassigned liability makes any sense. Nevertheless, the FCC has given suggestions for how companies can mitigate risk by either checking databases. There are databases of reassigned numbers, scrubbing them against those databases to determine whether or not the number has been reassigned. Also, before you start a phone call or text message, you send an informational message. Is this still your number? Is this John Smith? Are you still interested in receiving messages? Things like that. Or this is XYZ company, just confirming you want to continue receiving text messages. If you don't reply, no. Now, the consumer doesn't have to reply to that. The FCC has been clear about that. But these are efforts that could be taken to try to weed out any numbers that have been reassigned to third parties. There was also, I was actually speaking at a conference earlier this week in this area, and I learned about a technology that on the phone call front can detect when an answering phone, answering machine answers, and it says, "Hi, you've reached John or Mary," whatever it may be. And this technology captures that message and then bangs it up against the database name. If the name is the same, then they believe that they have a same subscriber. However, if it's different, it might be a reassigned number, and it flags the account and then is not called again in the future. So it's really kind of interesting, the different technologies intended to address this kind of unreasonable determination by the FCC. Now, all of this can change. There's so much stuff going on. There's so many events and occurrences. For example, I've been talking about throughout the program, the industry appeal of the 2015 rulings being considered on the topic of an auto dialer, and that has to do with whether or not a dialer has the capacity to auto dial, or it's being currently used with manual intervention, as I mentioned earlier in the presentation. Not going to get into too much detail here, but it's a very big issue. Revocation. that's on appeal, as is the reassigned phone number as well. All these issues are being considered by the DC Circuit, and a decision, I'm not exactly sure when, this is now February, I think maybe beginning of the summer or sometime then, some decision may be handed down, so we'll see what happens. But then we also have a changing of the guard at the FCC. President Trump recently appointed Commissioner Ajit Pai, to now be chairman, who replaces former chairman Wheeler, who's a Democrat. So for the last 8 years, the FCC has been issuing rules, regulations consistent with the TCPA's purpose in promoting consumer protection and privacy, which is what it should be doing. But because some of these rulings have been a little bit, or have been criticized for being unreasonable and not very clear, it is possible now that Chairman Pai, when he comes in as a Republican, can try to either repeal, pull back, or in some way alter or impact those previous rulings. So we'll have to see what happens there. We also have a number of courts issuing different decisions on the July 2015 issues. So you have this kind of perfect storm here of the appeal, changing of the guard at the FCC, and the courts issuing different decisions that may change the outlook on a lot of these, or at least the environment for all of these issues. What is not going away, however, are plaintiffs' firms, and that's always obviously the biggest risk because they have no accountability. They can bring claims whenever they choose. But based on these decisions here and what's going to happen, they will have a deterring effect on plaintiffs that feel that they can take advantage of the ambiguity in some of these definitions and to bring claims based on facts that are in the gray. And if there is more clarity or more industry favored decisions, then that might foreclose then and reduce or mitigate the number of class actions that are brought. So we'll have to we're going to keep up on that and see how that goes and follow those carefully. So you've now heard all of the issues and all of the concerns under the TCPA. So how do we avoid TCPA liability? How do we mitigate risk here? Obviously, I always tell clients, consent is king. Consent is gold. Get and maintain the appropriate level of consent. If it's purely for informational messages, transactional, non-marketing, make sure that you are getting a phone number from a consumer or a subscriber that they voluntarily provided to you. And when you're doing so, you have to be careful in the type of language you use when collecting that consent. You don't want to have limiting words. There was a case a number of years ago brought against Walgreens where a consumer walked up to the prescription counter, asked for a prescription. The sales associate said, I need your mobile number so that we can verify you when you come back to refill your prescription. They gave the phone number. Next thing they know, they're getting refill reminders. And putting aside the question of whether or not a refill reminder is marketing or not, what the court really focused in on was the misrepresentation. I'm sorry, the company then used them to notify of the refill events, and the consumer brought suit claiming that that's not the reason I gave my phone number. So you have to be very sensitive to and aware of the context in which the phone number is given and what you're telling the consumer it's going to be used for. Very, very important. For residential phones, use live agents and avoid artificial voices. Again, that's one of the issues I mentioned at the top of the presentation, where if you're going to be calling residential phones with a pre-recorded message, you need to have express written consent. If you have live agents, then that's not covered, only pre-recorded sales agents. For mobile phones, have live agents manually dial calls. That goes back to the auto dialer issue mentioned a moment ago. Calling a cell phone under the TCPA using an auto dialer, you need consent. If you don't use an auto dialer and someone sits at their desk and plugs in 10 numbers and that system is not hooked up to an auto dialer, they could, in theory, just make phone calls all day, even marketing messages, because it's not covered by the TCPA. But I do need to point out, and it's beyond the scope of this presentation, but there are a number of state laws that prohibit calling or texting cell phones without consent, even if no auto dialer is being used. That doesn't come into the equation at all. So you have to be cognizant of those state laws, even though the TCPA requires the auto dialer. have members identify the type of phone number they're being provided. Is this a landline phone? Is it a mobile phone? Also, hiring a vendor to scrub for phone type is still recommended. So if you want to try to scrub against wireless databases. Here we go. Also, scrub do not call wireless and reassigned databases. That will help you ensure that you're not calling people on a do not call list, numbers that have been reassigned or that are tied to a wireless phone number. This bullet actually goes to an earlier point I made about ensure the collection of the number is not limited or restricted. The only restrictions you would have are your own words. So if you don't put those restrictions on, you should not have those limitations. So you try to keep it as broad as possible. The flip side to that, though, is if you do keep it broad, what would the consumer reasonably expect the number to be used for? In that regard, the best protection would be to specifically state what the intended use will be. That way, there's no question as to consumer expectation. That is exactly what it is. On the other hand, if you use that language, you're limited solely to that purpose. And you have to consider whether or not you want to be boxed in with that or not. And again, these are moving targets. You have to determine what the purpose of the collecting the phone number is and how you intend to use it going forward. So you need to be you need to involve various constituents in making these decisions and trying to think big picture as opposed to very limited. And the various ways to get prior express written consent, member applications, subscriber applications, that's a great opportunity. When your customers log in, give them an opportunity there to receive text messages. Some consumers, for example, when I travel, I would rather get an alert by text message rather than email on my phone if I'm sitting in the airport or if I'm somewhere and my flight's delayed. I'd rather receive a notification by text message. So at login, that's something I might want to do. If there's a customer service call or an inbound IVR, try to collect it then as well. It can be introduced very positively, the consent, and then as long as it's recorded, then you should be fine as well. And last, online lead forms are a great way to get consent. This opens up a whole different topic, a different conversation about using third-party leads, lead generators, and negotiating and working with partners to get consent. It's very easy to get consent through these lead forms, but at the same time, if you're relying on these third parties, you have to ensure that the forms they're using are compliant. And that may require monitoring your partners. It may require them to provide links to the URLs they're using so that you can see what they're doing. And so some liability can possibly open up. But nevertheless, online lead forms can be used. With that, I think now, Mark, we've kind of completed the substance of the presentation, and I turn it back over to you if there are any questions from the audience.
Great. Thank you, Mark. That was an excellent summary of what is admittedly a complicated topic. I think that there were some key takeaways for me. I know when we first started having these discussions some time ago, Mark, I think the distinction between informational and marketing calls was a real eye-opener for me, and I think a lot of our customers are not aware of the fact that for informational messages subject to the caveats that you pointed out, you don't necessarily need explicit written consent to send messages. So I think that's an important distinction because we not only want to make sure customers are protected, but we also want to make sure that they're empowered to send messages via SMS where appropriate. So I think that was a key point. Do have some questions. I know we're over time, but we're going to keep going. If folks have to drop off, again, we're recording the webinar, and we'll send a link to the recording. But I do want to ask some of the questions or relay some of the questions that we've received from the audience, Mark, and then I have a couple of my own. First one, this was asked by an audience member. I had the same question when we were reviewing the slide with some examples of informational messages, and that is an SMS appointment reminder to a customer who originally called inbound for marketing purposes, but requested a call back later. Does that fall under informational or marketing for consent purposes? So maybe this is somebody that wants to get some information about a product or service. They've set up an appointment to talk to someone, and then in advance of that appointment, they get a text message reminder reminding them about that appointment. Does that?
It's an excellent question, and as all lawyers will say, it depends. I would feel, the bottom line is I would feel comfortable if the person wants a text message reminder to be able to send it to them. They've requested it. It has to do with a transaction, an appointment, and it's not necessarily selling per se. So it might be perfectly acceptable to send that and without liability. It depends on the context of what else the text message says. If it's just purely informational about the reminder, that might be fine. If it has any other information in it, it may not be. So you have to kind of be very careful there. And last, I always tell clients to look at the overall risk here of what the class would be. So for example, the risk of a class action would be where there's an outbound campaign where text messages or phone calls are being made, that potentially can have a huge exposure. But if we're talking about consumers on one-off matters like this, you probably don't have a class really. You may just have these one-off people that are going to receive these text messages. So the risk of at least a class action, in my view, would be very low.
Got it. Okay. Further to that point, Mark, I don't know if you can talk about the reassigned numbers issue. I mean, that is it's a thorny one, as you pointed out. But I'm curious, from a practical perspective, that's another area where it seems unlikely that a plaintiff's attorney would have an easy time building a class. Have you seen much in the way of sort of class action lawsuits built around this reassigned numbers issue?
Oh yeah, there have been a number of class actions brought in the reassigned area, and it is kind of a weird case to bring, because how do you know who those people are? They don't have to tell you that it's been reassigned, and when you're calling them, you have no knowledge that it's been reassigned. So how do you have an ascertainable class? And where the plaintiffs have come around with that is to sue a company based on one or two cases where someone did have a reassigned number, and then obtain databases that have reassigned numbers, and then bounce that up against the call campaign numbers. And then from there, you can determine the class. Is it as large as a huge campaign where there's unsolicited calls or text messages made? No, because right there, the entire call list would be per se a violation of the TCPA. But it's a much narrower and much more difficult class to prove, but nevertheless, plaintiffs' firms continue to bring them.
Gotcha. Okay, thank you. Another one is in regard to direct drop technology to cell phones. So direct drop voicemail with artificial voice. And I guess the question is whether there's a distinction between sort of direct drop voicemails versus sort of normal voicemails under TCPA.
Yeah, well, I think that's also, direct drop is also referred to as ringless voicemail.
Yep.
Where a voicemail is dropped into the phone without ringing, so a little light goes on the person's phone, or an indication or something pops up that says you have a voicemail, but my phone never rang. We're actually just doing a lot of research into that. No cases out there yet. The way the TCPA is worded is that it's placing any phone call to. Technically, you're not calling the phone. You're doing this voicemail. You're dropping it in. And so it's really a kind of a gray area that we've been just either reading kind of the tea leaves and FCC statements and the history of the TCPA to determine whether or not it would be covered. One of the issues, or one of the protections under the TCPA, is protection of privacy. Is a dropped voicemail invading privacy? Well, not really, because you haven't called the person's number, you're not interrupting, but now you're seeing a voicemail, and now they think that, oh, I have to go retrieve that voicemail. Well, that cost them money to do that in their plan. Could it be an invasion of privacy? We don't know. But we and others in the industry are kind of looking at them to see what type of liability possibly there could be.
Got it. Great. Thank you. So here's another question, and this is similar, I think, in a way to the appointment reminder question. So in this scenario, a consumer initially calls inbound for marketing purposes. They're put on hold, and while they're on hold, they're given an IVR option to receive an SMS to schedule a callback. If they press 1 to schedule a callback, is that adequate consent to call them back or text them back via an automated texting or dialer platform?
It's probably the same answer as before as to whether or not there's an appropriate consent there. The person calls in to make the appointment and press 1, or I guess the outbound calls it, whether or not they're providing their number per se, which is, well, that's required for prior express written consent, not just for express consent. Are they knowingly providing their number? It's debatable whether or not there would be liability under the TCPA. At the end of the day, again, I think that you have these scenarios where the risk of a class may be reduced because it's not a huge campaign with thousands and thousands of calls. But then again, if there is scalability here, and that's an option you are offering people, and everyone who presses 1 could possibly be part of the class, that could be a risk there. What I would probably suggest is when someone does, with the press 1, add a little bit of language there that informs the consumer what they can expect. Is it marketing? No, so you probably don't need the TCPA written consent disclosures, but if you do add some language that puts a consumer on notice, hopefully a court will recognize that as reasonable and an attempt to inform the consumer what's going to go on. So that should be sufficient.
Got it. Okay. One other question regarding third-party consent, which you touched on briefly. Scenario is you've got a company that's doing background checks on job candidates. They get the job candidate information from a recruiter, let's say. The candidate has provided the recruiter with prior express consent to be contacted via their mobile phone number in regards to their candidacy. Does that then give the background check company the permission to use their cell phone number to text them about issues related to the background check?
That's a loaded question. There's a lot of issues in there, but I think what the question may be getting to is whether or not a third party can call someone relying on a phone number provided to a different party. And the FCC and some courts have actually addressed that issue. And there are certain scenarios where it is acceptable for a third party to rely on consent given to another party in order to reach out to that person. There's some very specific examples that the FCC has given having to do with, for example, having packages delivered by a carrier like the thing called the Cargo Airlines petition that was approved by the FCC, where the deliverer of a product that you bought from an online store, if they get the phone number from the online store, they can contact you to let them know that the package will be delivered late. Even though you have no relationship with the delivery company can rely on the provision of phone number given by the merchant to let the person know the delivery will be late. We'll leave it outside your front door. Again, these are informational messages that might be considered desired or expected. Now, in the context of the question you just asked, Mark, is if it's disclosed to the applicant that they will be receiving a call from an entity checking their credit, then the person's on notice that they're going to receive the call, and that might be the best practice there to allow that credit check company to reach out to that consumer.
Got it. Okay. Yeah, it sounds similar to, I know we've seen cases recently where a third-party debt collector was found by the court to be able to rely on the consent, the prior express consent obtained by the first-party lender. So in that case, I'm thinking about the Sharp Healthcare case, Mark, where a third-party debt collector was able to use text messaging to collect on a debt owed to a hospital based on the phone number having been provided as part of the hospital registration.
Correct. So yeah, that's right. So debt collectors stand in different shoes. The FCC has expressly said that, and courts have acknowledged that, a debt collector who's collecting a debt for a creditor, and there was Sharp. There was also the Gulf Coast collection case down in Florida, where the courts are very clear that a debt collector can reach out to a consumer in connection with a debt owed to a creditor, and where the consumer gave the phone number for that service provided. So in the debt collection space, it's been kind of very clear that third parties can contact. In other areas, such as, again, I just mentioned a moment ago, the cargo airline, slightly different fact pattern. And again, these are all case-by-case basis. But there is some good case law and FCC language to support the fact that one person can get consent from the consumer and give that to another person to use if in connection with their transaction.
Got it. Okay. We are over time, Mark. This has been a great discussion. I think you and I could probably go on all day talking about compliance and consent. Hopefully, as you pointed out, some of the trends that are underway will help to clarify and simplify some of the rules around SMS compliance. But in the meantime, it's good to know we've got a good resource in you, Mark. We've got your contact information up for anybody that wants to follow up with you directly. And again, we'll send out a recording, a link to a recording of this webinar for future reference. So thank you again, Mark, specifically. Thank you to all of our audience members for joining us. Really appreciate your attention and your questions. And again, if you have any other questions, either for MessageMedia or for Mark at Manat, feel free to follow up with us directly after the webinar. So thank you again. Enjoy the rest of your days, and we'll talk to you soon.